This is DevAI, focusing on newest developments in AI legal space. Please subscribe to my channel. The Cyberspace Administration of China released draft administrative measures for generative artificial intelligence services. For public consultation, the draft measures would regulate generative artificial intelligence services that are provided to the public in mainland China. These requirements cover a wide range of issues that are frequently debated in relation to the governance of generative AI globally, such as data protection, non-discrimination, bias, and the quality of training data. The draft measures also highlight issues arising from the use of generative AI that are of particular concern to the Chinese government, such as content moderation, the completion of a security assessment for new technologies, and algorithmic transparency. The draft measures thus reflect the Chinese government's objective to craft its own governance model for new technologies, such as generative AI. The draft measures apply to research and development into as well as the use of generative AI that is offered to the public within the territory of China. Generative AI is defined as technology that generates content in the form of text, picture, audio, video, and code based on algorithms, models, and rules. It is unclear from the wording of the draft measures whether the public refers to consumers in China, thus excluding generative AI services offered to enterprises from the scope. It is also unclear whether providers of generative AI outside of China that is not specifically targeting the Chinese market will be subject to these rules. The draft measures define a provider of generative AI as an entity or individual that utilizes generative AI products to provide services such as those that generate chat, text, picture, and audio. Note that this definition includes service providers that allow others to generate chat, text, picture, and audio through API or other means. The draft measures do not distinguish between providers of generative AI offering backend technologies and those that build services at the application level. Both are responsible for content produced by generative AI products and are required to protect personal information in accordance with China's personal information protection law. Furthermore, in Article 4 of the draft measures, requires the providers of generative AI to adhere to the following principles. First of all, they have to ensure that the content created by generative AI is consistent with the social order and societal morals and does not endanger national security. Furthermore, they have to adopt measures that avoid discrimination when designing algorithms, training datasets, and providing the services that incorporate this generative AI. Furthermore, they have to ensure that the content created by the generative AI is true, accurate, and free of fraudulent information. And fourth, they have to respect intellectual property and comply with all other applicable laws and regulation. Providers of generative AI are required to adopt measures to filter any inappropriate content created by generative AI and optimize algorithms to prevent the generation of such content within 3 months. Providers of generative AI are also required to enable the use of tagging mechanisms to identify content, video created by generative AI in accordance with the provisions on the management of deep synthesis of Internet information services. Before offering a generative AI service to the public at large, under the draft measures, a provider must apply to the CSE for a security assessment in accordance with the provisions on the National Security Assessment of Internet Information Services with characteristics of opinions or capable of societal mobilization. These are also called the assessment provisions and are declared in Article 6. The assessment provisions were released in 2018 with the objective to cover Internet information services such as public forums, live streaming, and other types of information sharing activities online. Under the assessment provisions, in-scope service providers are required to carry out a self-assessment or engage a third-party agency to carry out the assessment. Factors to be considered in the assessment largely overlap with the requirements provided under the draft measures, including, for instance, the verification of real identity of users, the technical measures adopted to protect personal information, and the internal mechanisms for content review. Providers of generative AI are also required to file certain information regarding its use of algorithms with the CSE in accordance with the requirements provided under the provision on the management of algorithm recommendation of Internet information services. This includes, for instance, the name of the service provider, service form, algorithm type, and algorithm self-assessment report. Furthermore, providers of generative AI are also required to ask the end users to provide real identity information. Furthermore, such providers must specify the targeted end users and use cases of the services provided, and adopt measures to prevent end users from becoming addicted to the services. Providers of generative AI are also required to disclose information that might impact users' choices, including a description of the source, skill, type, quality, and other details of pre-training and optimized training data. Furthermore, rules of manual labeling, the scale and types of manually labeled data, as well as fundamental algorithms and technical systems. At present, it's really unclear how such information should be disclosed or to whom such information needs to be disclosed to. Furthermore, providers of generative AI are required to protect data submitted by end users as well as the activity logs of end users. Providers are prohibited from conducting user profiling or sharing information related to the end users with third parties. Providers of generative AI must also establish a mechanism to intake and review complaints from end users. Finally, providers of generative AI should guide end users to properly utilize generative AI and not to use it to damage the image, reputation, or legitimate rights and interests of others, and do not engage in commercial hype or improper marketing. Specifically, if a provider of generative AI discovers improper use of the technology by its users, it should suspend or terminate the services provided to such end users. In addition, an end user can report a provider of generative AI to the CSC if the generated content does not comply with the requirements of the draft measures. Furthermore, Article 7 of the draft measures also impose obligations on the research and development of generative AI. Specifically, providers of generative AI must ensure that data used for training and optimization is obtained from legal means, and such data must comply with requirements stipulated by the cybersecurity law, thus should not contain any content that infringes intellectual property, and also if it constitutes real personal information, then it has to be really obtained on the basis of consent from the data subjects, or has to comply with the requirements provided under applicable Chinese laws and regulation. It has to be accurate and objective, as well as also sufficiently diverse, and it has to also comply with regulatory requirements related to generative AI released by the CSC. Providers of generative AI must also define clear rules for data annotation and train employees involved in such annotation. Further, providers of generative AI should not generate discriminatory content based on race, nationality, gender, or any other characteristics of the users. Finally, and most importantly, are the penalties that are stipulated in Article 20 that really specifies a provider of generative AI that violate the requirement under the draft measures have to be penalized in accordance with the Personal Information Protection Law, the Cybersecurity Law, Data Security Law, or other relevant regulation. And if these laws and regulations do not specify a particular penalty, a violator may receive warnings or may be ordered to take corrective actions, or more severely, may even get his service suspended and have to pay a fine, as well as might be held criminally liable. Instead, while the law is still in the drafting stage, the measures provided really provide an insight into the new regulation addressing the legal gaps related to generative AI. This is DevAI, focusing on newest developments in AI and legal space. Please subscribe to my channel, put any questions or feedback in the comment section. Goodbye.